Hi, everyone. Good evening. Carl Steinbeck here. Friday night, want to talk about the latest on the Florida versus Donna Adelson case. We've already had her convicted on all 3 counts: first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. So with that, normally in most states in America, you have 30 days to file a motion for a new trial. So that's pretty much standard for attorneys to do. And in this particular case, there's not a lot that the defense attorneys have to work with, just like they didn't have a lot to work with at the trial. So what I'm going to do is jump right into the actual motion that was filed by Donna's 2 attorneys, Fulford and Zellman here. So let me go ahead and maximize this. Actually, there's a way I can maybe... And I guess that's the way it's maximized. So what we have here is, it's only an 18-page motion, and I'm just going to basically tell you how I'm looking at this as I'm going through it, trying to see if there's anything significant, anything of a concern that I'd be worried about if I was a prosecutor on this case. So this motion is filed, they're saying within 10 days of the verdict. So most states it's like 30. Here, and I guess in Florida, it's 10 days. And what this initial request is for the defense to interview juror number 5 and juror number 7. And they're saying that the new trial could be granted on ground 1, juror misconduct; number 2, verdict contrary to the law or weight of evidence; 3, the court erred in the decision of any matter of law which arose during the trial; and 4, any other cause not due to Ms. Adelson's fault. She did not receive a fair and impartial trial. So this first thing they want to do is ask for a motion for leave. That basically means permission of the court to interview jurors. And then they go on reciting how the standard instruction was saying you're not permitted to communicate to anyone about this case, including spouse, family members, neighbors, and even your fellow jurors. No communication, they bold italicized. No communication includes in-person, telephonic, electronic communication. So communicating about this case includes posting information on social media or a website. They're highlighting that, posting information. So they're saying that subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on October 26th, of 2025. Flash drive of this video will be provided to the court, as the undersigned has been informed that the particular TikTok was deleted by the juror from her account. The undersigned seeks to interview juror number 7 concerning her social media activity during the trial. So they don't have anything to go on. She just saying, hey, I'm a member of this jury. And apparently, before she deleted anything, she had they had a chance to look at this. And I'm sure they're looking at this during the trial as well. So for them to now claim this is an issue after the trial, it's just merely saying you're on the jury. I mean, I think that's not what this means. Posting any information about the case. It's not about the case. It's about the, hey, you have jury service. So I don't think that's an issue at all. So they're trying to do some kind of fishing expedition. I don't think the judge is going to grant this one here for juror number 7. Let's go look at number 5. They're saying juror number 5 appeared on Surviving the Survivor podcast. And during this time, he revealed that he considered how Ms. Adelson reacted to the evidence and testimony admitted during the trial. Although he subsequently stated he obviously did not consider that during deliberations, that he considered Ms. Adelson's reactions whatsoever is concerning, as her reactions are not evidence and are extrinsic or external rather than that which adheres to the verdict. As a result, they want to interview number 7. Well, okay, so what did he... How's that not something to be able to talk about? Is her demeanor, her reactions to evidence? I mean, something you can note as a juror. Hey, the defendant was unruly, making nasty comments that we could hear as jurors. I mean, that's not considered evidence from a witness box or anything like that. They could see her hatred things of that nature, obviously, is something that a juror member is going to pick up on. So that's totally appropriate comment to make. And here you could see how Donna was very much doing a performance, especially when they had the gruesome photos of Professor Markel being showed on the big screen there for jurors to look at, and she's acting like she's crying with those fake tears. So you tell me, a jury member, that's inappropriate to ever comment on it or think about it? Yeah, did you notice her reaction? I mean, they could all be talking about that. That's what jurors do. So there's nothing here. And then they talk about the law, and they say that potentially harmful juror misconduct is presumptively prejudicial. A party seeking a jury interview does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudices his case. Rather, it's only necessary that the party establish a basis for an inquiry or the grounds the party believes may exist. So, you know what? This is not even something that rises, I think, to a level that they should be inquired into. I think the judge is going to summarily dismiss these. Once improper contact or juror misconduct is established by juror interview, the moving party is entitled to a new trial unless opposing party can demonstrate that there's no reasonable probability that juror misconduct affected the verdict. So there's no misconduct here that needs anything to be addressed by the court. It's just going to be some kind of fishing expedition. And like I say, both of these should be disregarded by the court. If juror misconduct is confirmed by the jury interviews, the other side will request leave to make more extensive arguments concerning why juror misconduct in this case warrants a new trial. So yeah, you're on a fishing expedition. So you got nothing there. So really, that's it. That's it, Zellman. So number two, part two, is they are saying that the verdict is contrary to law or the weight of the evidence. And then they talk about what the standard of review is for the Court of Appeals. Actually, this is going to the trial court only. For the weight of the evidence is by motion for a new trial at the trial court level. And they talk about how the rules of criminal procedure and the court continue to recognize the critical need for some form of discretionary judicial review to serve as a safety valve in those cases where the evidence is technically sufficient to prove a criminal charge, but the weight of the evidence does not appear to support the jury verdict. And so they're asking the court to evaluate whether the jury's verdict is contrary to the weight of the evidence and to act in effect as an additional juror. This is different than the standard that the court uses asking for when the defense asks for a motion for judgment of acquittal, which utilizes a sufficiency of the evidence standard. So that's something what the defense did after the prosecution rested. Florida courts have held multiple times when considering motion for new trial under the Rule 3.6, based on a claim that the verdict is against the weight of the evidence, the court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. So they're saying that the court acts as a safety valve by granting a new trial where the evidence is technically sufficient. They're just basically restating the case law. So they're trying to say that the weight of the evidence doesn't appear to support a jury verdict. When determining the weight of the evidence, in essence, the trial court acts. I guess I'm just restating more of that same phrase. Safety valve, when it's technically sufficient to prove a criminal charge with the weight. So basically saying there's not enough solid evidence. It's sort of flimsy. It's on shaky ground, the kind of thing. And it says here, the role of the trial judge in passing on motion for a new trial on the ground that the jury verdict is contrary to the weight of the evidence is to weigh all the evidence and determine credibility of witnesses so as to act in effect as an initial juror. And then they go on to start out by talking about the count one, first-degree murder. The court must make a finding that Patricia Bird was credible before considering Ms. Adelson's alleged confession to Bird. Under no set of circumstances can Bird be considered credible. She testified the defense investigator with whom she spoke was a white woman. Ms. Khan was obviously not white. She further testified she told Ms. Varnes, Ms. Khan, that Ms. Adelson confessed, and Ms. Adelson offered her financial incentives in exchange for perjured testimony. Both Varnes and Ms. Khan disputed those claims. Mr. Varnes, I should add. Initially, Ms. Khan said she never met with Ms. Adelson. Thus, unless the court was to believe defense counsel conveyed to Ms. Khan that Ms. Bird was to be offered money for false testimony, Ms. Bird's testimony should be disregarded completely. The same is true of Drina Bernhardt. Her motivational lie was and is significant, with 27 felony convictions and facing a mandatory minimum 15-year prison sentence as our prison released the reoffender. Her credibility was significantly impeached. The only one who testified, this was Ms. Adelson's word rather than Ms. Bernhardt, it was Ms. Bernhardt. However, surveillance video admitted into evidence established that she and Ms. Adelson worked together to write the script. Yeah, okay. So the script was Charlie Adelson's defense, his outrageously crazy defense story of being robbed with a payment plan, a layaway plan. So, like, she would know all those details to look all that up. It's obviously so much that it came from Donna. Is obviously Donna trying to set her up for that and promising her things. So that's but you don't even need these two witnesses here. Just Donna's own actions outside of these two jailhouse informants is the weight of that evidence is entirely sufficient to make these convictions stick. They're saying here in number 24, the theory of the state's case was that defendant is guilty as a principal to the charge of murder because she agreed to the plan that was carried out by her son. And that included also Katie McBanois, Sigfredo Garcia, and Luis Rivera, and that she paid for the crime to be carried out. There's no evidence that Ms. Adelson committed any act or uttered any words in furtherance of the offense prior to being completed, and for that reason, the evidence is not sufficient to support her conviction as a principal of first-degree murder. Additionally, there is no evidence other than adoptive admission from Charlie's trial testimony that Ms. Adelson was aware of her son's plans until September 17th of 2014. Keep in mind, Dan Markel was shot in his garage on the 18th of July of that same year, 2014. So what they're doing here is conveniently leaving out other information, that there was a lot of pressure to help rescue Wendi. She was about to be facing some horrendous court actions, could lose her job, could be in trouble with the state bar. And there could be things against Donna to include supervised visitations based on her ridiculing Professor Markel in front of his children when he wasn't there. So they also leave out the code language for the paella birthday celebration for Harvey, where they made a big deal about his 70th birthday, but then they couldn't remember what kind of gift they gave him, and the Florida Adelsons anyway. So as it turns out, the first murder attempt was supposed to happen before his birthday, but it happened, let's see, what was his birthday? The 5th, I think it was the 5th of July, and so Professor Markel got gunned down just on the few days later, a couple of weeks later, on the 18th. So you're leaving a big chunk of evidence out. Although the person can be convicted as a principal to a criminal offense based on words alone, there must be a competent, substantial evidence these words are spoken in advance of the crime. Well, they got her making a text message saying, "I know you'll come through," to Charlie when they're talking about getting this paella for the birthday party celebration for Harvey. And a person can be convicted as principal to a crime under section 777 of the Florida statutes only if there's evidence that he or she committed some act or uttered some words to assist another in the commission of the crime when the crime is being carried out. There's also circumstantial evidence to show she had foreknowledge as well, based on her total involvement once the wire tapping was going on. And we heard how much her and Charlie were acting in concert. And then they want to cite here under paragraph 26, in order to be found guilty as a principal, you must do some act to assist the other person actually committing the crime. Well, that includes making payments. So making payments is clearly circumstantially proven easily in this case. You're telling me that while he was dying in the hospital, Markel then not having a chance to survive, then she decides to go ahead and pay and drive that money by Charlie's place to pay the hit team. Yeah, I doubt she decided that day after he was shot. So the court's going to look at it the same way. Yeah, there's also no circumstantial evidence Ms. Adelson wanted Mr. Markel to be killed. Okay, well, obviously they're leaving out key details. Even if there was, so yeah, there's no circumstantial evidence. Even if there's no evidence to establish the second element that she did some act to assist the other person actually committing the crime. And then they talk about McVanwell testified that parents stopped by Charlie's place after Mr. Markel was murdered. He technically was still alive. However, McVanwell did not testify that Ms. Adelson or her husband dropped off any money that night, and the state's expert agreed the state could not place Ms. Adelson's or Dr. Harvey Adelson's handsets at Charlie Adelson's residence. Well, she said they were there. Okay, so you're going to leave that out? Very misleading by the defense. Even if, here's another, even if, in other words, yeah, we know we got a loser argument, but even if Ms. Adelson and Dr. Harvey Adelson did stop at the residence, it would have been approximately 9 hours after Mr. Markel was shot. 27, they're saying, in fact, the state's request, this court found that Ms. Adelson had adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid McVanwell from his own money, which he kept stapled as confirmed by McVanwell, Ryan Fitzpatrick, and Chunam Chinda. So they're going on to say there's no evidence that Ms. Adelson was aware of anything other than Mr. Markel had been killed prior to September 17th, 2014. Yeah, that's not quite true either. You're leaving out conversations that they picked up in text messages between Charlie and his mom, Donna. So the prosecution will clean up this gross mischaracterization. And they're talking about it in the Staten case. Affirmative acts must be used to prosecute someone as a principal. The jury could legitimately infer that petitioner was a participant in the crime. Yeah, you can legitimately infer based on all the evidence against Donna that she was totally up to her eyeballs in the murder of Professor Markel. Anyway, I'm not going to go over every single point of law they're mentioning here. So here they're talking about the Williams case, Denise Williams. Yeah, they're saying at a minimum there must be some proof of an overt act or some words uttered in furtherance of the scheme that led to the murder. Okay, well, they have that, so I'm not worried about that. However, nothing about delivering money after the murder could support her conviction as a principal to the murder itself. Additionally, there's no evidence of what Ms. Adelson agreed to pay the killers prior to the murder. In fact, McVanwell testified during the trial the amount of payment was never addressed prior to the murder. And again, they say that the state may argue that Ms. Adelson necessarily provided Mr. Markel's tag number to her son or gave it to McVanwell, who then gave it to Garcia and Rivera. However, there's no evidence that the tag number was ever given to Charlie, let alone McVanwell, Garcia, or Rivera. Even if such evidence existed, there's no evidence it was done before July 18, 2024. There was no evidence that was admitted during the trial to establish the purpose for which Ms. Adelson had the tag number on her 2014 planner. So Well, it's pretty obvious circumstantially what the tag number was there for. Again, even if Ms. Adelson dropped cash off at Charlie's house after the murder and signed the payroll checks after the murder, was established as culpability as accessory after the fact, but they're not competent evidence as principal to first-degree murder. So, okay. You're not defending those check payments, I guess, and the cash payments. So it basically sounds like you're conceding that she paid for the murder to happen. You just don't have enough words spoken ahead of it to describe it, but there's circumstantially there. I think the prosecution has the best indication being the messages Donna sent regarding the paella, finding paella being basically the hitman, paella being code for the hitman. That the state needs to argue to counter this. Then you have count 2, conspiracy to commit first-degree murder. Again, they're trying to attack it as being not any direct evidence of conspiracy to commit murder. And they talk about evidence that the flight was not that she was fleeing to avoid prosecution, but that at the time in November 2023, she believed her son's innocence, and that if he were convicted, the state would turn their attention to her. Rather than consciousness of guilt, that is evidence of a real fear the witch hunt would continue. A witch hunt, huh? The trial must exercise discretion in determining whether there's a greater amount of credible evidence supports one side of an issue or another. Although the fancy presentations prepared by the state may have persuaded the jury, Ms. Adelson asked the court to look objectively at the evidence, removing the improper stacking of inferences on which the jury's verdict is premised. So they're not really saying a whole lot there. They just talk about flight. Okay, I guess I skipped this one. Slide 10. Although there's certainly evidence Ms. Adelson was not happy with the way Mr. Markel was treating her daughter in the litigation process, there was no evidence Ms. Adelson said or did anything to suggest Mr. Markel be killed a year after relocation was denied and the dissolution of marriage had been settled. No, it wasn't settled. There again, you're misleading the court. There's no evidence Ms. Adelson was even aware, according to Jeff Lacasse, that Charlie Adelson was looking to hire a hitman in summer 2013. Well, circumstantially, you can see that this family was totally, the Florida Adelsons are totally enmeshed in what was going on with Wendi and trying to rescue her. And they're trying to say here that to establish a prima facie case of conspiracy, the state had to admit evidence that Donna had the intent to have first-degree murder to be committed, and that in order to carry it out, she agreed and conspired, combined or confederated with Charlie, Catherine, or any other persons for first-degree murder. Yeah, so they basically fall like dominoes. You're guilty of first-degree murder, and you're going to be found guilty as 2 others as well. They're saying, where's the evidence Ms. Adelson agreed, conspired, or combined, or confederate with anyone else that Ms. Markel be killed? There is none. And they're trying to say, again, this is all speculation and whatnot. No, it looks like she's totally involved, from working on getting the TV repaired, quote unquote, the code for the murder, to working it so intently on the wiretaps. I mean, that's, like I say, she's up to her eyeballs, wrapped around the axle on this involvement to make sure Dan is executed. Number 3, count 3, solicitation to commit first-degree murder. They're saying the state's theory on count 3 was that Donna convinced her son Charlie to find someone to murder Dan Markel. The charge requires someone intends the crime to be committed, and that she commands, encourages, hires, or requests another person. So here again, solicitation recites those same terms: commanded, encouraged, or hired. The evidence submitted at trial failed to establish that Ms. Adelson asked anyone earnestly or tried to induce anyone. Ms. Bangway did not testify as to any messages Charlie conveyed to her, and Charlie, although transported from prison to testify, was not called as a witness. Well, they were totally talking all the time together about this case. As with argument concerning count one above, the evidence may have established her involvement after the fact. Her complaining to Charlie about how Markel treated Wendi. There's no evidence she commanded, encouraged, hired, or requested Markel to be murdered prior to the murder. Well, she's talking about, I'm sure you'll be finding a hitman, basically, by that paella request. And she's the main one that had motive to get this thing off the ground and running, because she had her help rescue Wendi. Wendi was able to push the buttons. She was able to light the fire under her mom, who then lit the fire under Charlie to make sure it happened. Again, they're trying to say improper stacking of inferences, so it should be set aside, new trial granted. So not worried about this one here. We have the totality of the evidence indicates that this was a total family affair of the Florida Adelsons from start to finish. There's different pieces here and there where you don't have direct evidence that they were involved, but from this circumstantial evidence showing how they interacted with each other, it's very clear Donna was an integral part of this. So I don't see the state setting this one aside. And then they're trying to say here in Roman numeral 3, the court erred in a decision of any matter of law which arose during the trial. So then he starts going into trying to admit the complete planners. Remember, we had the 2014 planners for Donna, and they're saying that they wanted to introduce the entire one to correct the misrepresentation expected to be made by the state, which came to fruition during the state's closing argument. The state argued that Mr. Markel's tag number in the planner was evidence. Ms. Adelson provided the tag number to the shooters. Rivera testified that there were words on the photograph given to Garcia, but no evidence was offered of what those words were. They're trying to say, well, there's no evidence that this tag number was directly given to the killers through any other conspirators, but that's an inference you can make, a logical inference you can make. With the 2023 planner, the state argued that the planner indicated in anticipation of fleeing the country that Ms. Adelson was selling personal items. Admission of a complete planner would have corrected the misrepresentation by the state, as there was 39 other entries in the planner where Ms. Adelson listed to sell identical items as far as back as January 23. And then they cite a case here that talks about how judges have a duty to admit evidence that does not fit neatly within the confines of the evidence code in order to protect the defendant's rights to a fair trial. The court admitted both portions of the planners. Therefore, there's no question that the authenticity of the materials, exclusion of the planners, infringed on her right to present a defense. And the evidence was important to defeat the argument that she was fleeing to avoid prosecution. Yeah, this sounds so weak. It's not even worthy of being commented on any further. Roman numeral 4, for other cause not due to Ms. Adelson's fault, she did not receive a fair trial. This cites the due process clause, guarantees the right of a state criminal defense to be tried by an impartial jury. I go on citing some more quotations from opinions. And it goes on to talk about in Paris 61, they cite a court case where it says the presence of courtroom observers wearing uniforms, insignia, buttons, or under indicia of support for the accused, the prosecution, or the victim of the crime does not automatically constitute denial of the accused's right to a fair trial. However, there's situations where the atmosphere in the courtroom might infringe on the defendant's right to a fair trial. When such a claim is raised, the case-by-case approach is required to allow the courts to consider the totality of the circumstances. So a defendant claiming they were denied a fair trial must show either actual or inherent prejudice. Actual prejudice requires some indication or articulation by a juror or jurors that they were conscious of some prejudicial effect. Inherent prejudice, on the other hand, requires a showing by the defendant that there was an unacceptable risk of impermissible factors coming into play. And they're saying this is a case where the cumulative effect of a number of factors resulted in prejudice to Donna. When the court would rule against Donna on many occasions, the members of the gallery supporting the state would laugh out loud. Counsel for the defendant brought this to the attention of the court. The court appropriately advised the gallery this is not acceptable. The court did this on more than one occasion. However, the conduct continued throughout the trial, and the court took no action to remove those who violated this order. This undermined the credibility of the defense in the eyes of the jurors. Not only were they laughing out loud, videos and images captured throughout the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. This interfered with the jurors' ability to focus on the evidence and distract them from closing arguments. You know, he didn't make all these details out that we saw. Maybe it was on sidebar, but we never saw any of that. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. The law does not require that a defendant appear without any emotion. In fact, as in this case, appearing to be cold to the seriousness and evidence in this case may cause a jury to believe the defendant had no care or concern for what the victim endured. Well, sorry, Selman, you're not talking about how your client was basically defiant through much of the trial, shaking her head, trying to do verbal outbursts. So there weren't jurors mocking and stuff like that throughout the trial as you're talking about. I never saw it when I was down there. John was there for all the testimony. He didn't see that kind of stuff. And you know what? The whole time the jurors, almost exclusively every single of the time I was there for what was it, the last day. And you know what? The jurors looked forward the whole time. I think only one looked at me and in the direction of the gallery there. So they were not paying attention to who's coming and going, and I did not see any expressions. So this is grasping for straws. Yeah, laughing out loud. Yeah, you know what? If they'd have been laughing out loud or was a disruption, the judge would have kicked them out. I mean, even just a cell phone going off got people in trouble, and they would not be allowed back in. And then they say here in 67, during the course of trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. No, she's shaking her head in defiance. She did become tearful during her first sight of autopsy photographs and got choked up when her children appeared to testify against her. She did not speak out. She's not sobbing out loud. She was not crying out. She did need tissues to wipe away her tears. No, she didn't. She didn't have any tears, so that's another misstatement. But she made no noises that distracted the jury in any way. Even the victim's parents noted that she showed no remorse due to her lack of emotion during the trial. No, it was defiance. It was defiance was the main thing of her emotion. This impacted the decision of the jury. So if she's not acting up and yet she's getting scolded by the judge, then how does this affect the jury? I don't understand the connection here he's making. So you're saying because she had no emotion, therefore the jury didn't think she showed remorse or the seriousness of the crime that someone was murdered? I guess that's what they're trying to say. Oh yeah, here, cold to the seriousness of the case. Yeah, well, she did appear cold. And when she tried to have tears, she couldn't. She was just faking it. Then they're trying to say, look here, this issue. On the second day of the defense's case, the court demanded Ms. Adelson decide whether she would testify. Both counsel for Ms. Adelson as well as Mrs. Adelson herself repeatedly advised the courts that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during the trial in order to make a knowing and intelligent decision in what was probably the most important decision of her life. This is especially significant in the fact the state made numerous changes to evidence during the trial. And they talk about the time they spent to prep her and meeting with her during the trial. Not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel in contempt of court because they were continuing to speak to their client about this important decision she had to make, which again brought an audible derogatory response from the gallery. No, I didn't. There was nothing that I recall hearing about any of this. The jurors are very quiet. There was a deputy there. In fact, there was one female deputy that you whisper to somebody and you'd be having her single you out and say, you got to leave right now. So it was very quiet in there. So they're just grasping at straws. They're basically almost alleging ineffective assistance of counsel, which could be a basis for reversing the case on appeal, because they're saying their client didn't make an informed decision, that they didn't inform their client. You inform your client well before the trial, all the issues, the type of evidence that's going to come in. You get them prepped to testify. So your client is prepared to testify. All right. So this is basically an admission that they did not spend the time they needed to adequately prep Donna to testify. So really very oddly written here. They're saying whenever the state needed additional time to set up electronics for opening statements, for witness testimony, for closing arguments, and even additional time to make their closing argument, this court not only gave them additional time, he joked with the prosecutors about it, thus leaving the clear impression that he favored the state in this case. Surely the decision of a defendant facing life in prison more important than extra time the state requested to conclude its closing. Defense request not granted made a huge impact on the outcome of the case. Really? So Donna not testifying made a huge impact on the outcome of the case? Wow. All because she wasn't prepared? I remember Fulford was saying, like, we need time to go over. There's a lot of evidence. I mean, we need time to go over all this evidence and talk about it in detail with Donna. Really? You can go over every little bit of information and spend weeks talking to Donna about that? No, that's not the way courts work in America. You better be prepared. The flow of the court is such that after your last witness, your defendant is normally the one that defense counsel have testify, and they better be ready. You're not going to be granted a delay to get them prepared. They had enough time. They had weekends, they had nights. This wasn't a one-day trial. They had plenty of weekends and nights to go in and meet their client and talk things over. What it really came down to is Donna was terrified because she knows she'd get smoked on cross-examination, and she would have gotten raked over the coals. So that's what she was afraid of. The court showed favoritism to the state almost every juncture of the trial. They're complaining that the state had ability to have delays, but the defense didn't, having to do stuff over lunch. And it also resulting in inability to consume lunch over break. Really? So now we didn't get a chance to eat? This is just ridiculous. And they're just whining about the state, sustained objections. All right, the court has sustained objections to the state without giving the defense the opportunity to respond. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied defense's request to approach. Anyway, saying that when the sidebars concluded, the court announced to the jury that the objection was overruled. Yeah, that's what they do. Talk about how the counsel was met with a scolding to not talk over the court. Counsel thereafter was prevented from answering court's question. I mean, this sounds like such whiny, sniveling stuff here. The temperament of the court towards the defense counsel was regarded as negative and gave the appearance of impartiality for the state on the part of the court. Fellow defense attorneys commented that they had appeared before the court on similar charges, and they were shocked to see the obvious disdain the court showed Ms. Adelson and her counsel. That's a really outlandish, inflammatory thing to make against this most highly honorable and esteemed Judge Everett, who's as fair as can be, and put up with your lack of preparation. Your lack of preparation was the worst I've ever seen in a trial. You had two attorneys that could have divided up the work. You guys were the most unprepared attorneys I have ever seen in a court of law. And you're going to say the judge shut you down, didn't give you a chance to prepare. He sat there and gave you all this extra time. I would have lost my patience with these clowns if I was a judge. So they're just basically doing a smear campaign against Judge Everett. This is like, the thing is, they're not like out-of-state attorneys that are coming in there, never going to see this judge again. Fulford, I guess, really doesn't practice law much, mostly working in their, funeral home. But Zellman, he practices there all the time to make these kind of pop shots at the judge. I'm really surprised by this. So there it is, Zellman and Fulford. Yeah, this is just really weak, embarrassing stuff. I'd be ashamed to be associated with something like that if I was a defense attorney. They have nothing on the judge, and you're asking for your reputation's damage, I think, if you do this kind of thing. Yeah, D-Mark, I agree with you. Defense had nothing and still grasping at straws. So if I was sitting back, if I was the prosecution, I'd be looking at this going, yeah, they got nothing. They got nothing. We'll be fine. Doctor, you're saying it sounds like Harvey and Donna wrote these complaints. Yeah, it's really, really not sophisticated writing at all. They didn't put a lot of work into this. Glad you feel better, Jody Roser. Yeah, they're not going to win. Justice Redan will prevail on this defendant. Yeah, Lissy Pease. I saw someone say Adelson has spent $6 million legal fees. I said $5 million. I thought at least $5 million. Didn't they have a net worth of $8 million a few years ago? Yeah, that was back in 2014 to 2016 range, maybe 2013 to 2016. I think what it was presented in Charlie's trial. So not sure how many millions they have left, but they may be running out before long. Amber C. Wendi was way too smart to have any direct contact with Sigfredo and Lewis. Not even Charlie had direct contact with them. Katie didn't even tell him that Sigfredo was doing that. I don't know why people use the word smart, too smart to have any direct contact. Oh, number one, we don't know for sure how they could have communicated. She now is, after saying basically previous trials on WhatsApp, she didn't think she had it. Now she's saying she might have, or something along those lines. So her testimony this last time in this trial, she's much more careful with her wording. Before, she's just flippant about things she was lying about. In this one now, she's more guarded and trying to bob and weave about this one. Yeah. Tina Moose, the defense even had a 3-day weekend to prepare after the state rested. They had plenty of time. I'm just telling you, I've never seen an attorney say they don't have time to advise their client. Okay. It came down to your client didn't want to testify and wanted to blame somebody else. And you went along with it and said, well, we didn't have time to prepare her. That's basically saying, Your Honor, I'm ineffective in explaining this to my client, and you're making her make a decision now. So you're basically setting this up for ineffective assistance, which is really, really bizarre. I just never have seen attorneys throw themselves under the bus like this for a defendant. You guys are making more money than you ever have from any other client in your lifetime, and you can't even get this client prepared to testify. You are prepared to testify. That's the bottom line. You are prepared. And if you're not, your client's not prepared. It's one thing if your client just never feels comfortable answering the questions. They can't keep track of one lie after the next. You try going over it with them. Hey, we're going to ask you this series of questions. Let's go through a mock scenario. I'm going to act like I'm having you testify in court. So let's go through this, and I'll critique you at how you're answering questions. And so you're telling me that you never did that with your client? And the evidence was so different at trial that you could not have adequately prepared your client. You're making excuses after excuse as to why your client's not prepared to testify. I mean, you're basically throwing yourself under the bus. Yeah. Yankee City girl, it would have been worse if she testified. Donna testified. Yeah, Archie, yeah, she wanted to trial early and then she couldn't wait to prove it, how innocent she is and testify on her behalf. Net detective, you're saying you could do better with her defense. Yeah, I think most anybody here tonight could do a better job. They're learning about the case as it went along, not prepared, period. You guys are pretty sharp on this thing. Toto, can you comment on Tim Jansen calling you crazy and saying he'd put his core experience against yours any day? He didn't use your name, but he's definitely referring to you. Yeah, somebody sent that to me today. It was pretty comical because he's he cited his 40 years of trying cases, and he acts like I've not tried any. It's like, well, gee, if I have zero experience trying cases, then why are you wrong all the time, and why am I right so much of the time, huh? Name one thing I've had to eat a lot of crow on. I mean, his opinions are like the weather vane. They spin and constantly flip around and all that. My opinions are very consistent. Why? Because I have some general idea what it takes to win cases. Look at all the predictions he had wrong. He said if you had Katie McBanois testify, you'd lose the case. He said they weren't going to call her. He also said that Charlie had a 50-50 chance while the jury's deliberating and getting a hung jury. A 50-50 chance? Remember when he said that he talked to Rashbaum for a couple hours talking about the jury selection, and he gave him some ideas of what Charlie's defense was going to be, and he thought it was something really novel and something that might work. And then yet, what did he say after the trial's over? It's the worst case he ever saw, worst theory of a defendant he's ever seen. That's what I've been saying all along. So when I heard that, I was laughing in opening statements. He wasn't. So anyway, the guy's whatever. He's flip-flopped on Wendi so many times. After the trial, he says, yeah, on Donna's trial, after she got convicted so fast in a little over 3 hours, he says, yeah, it looks like Wendy's going to be next. And now a couple days ago, he's saying, no, they don't have anything against Wendi because of a whole bunch of problems with, her testifying. You don't use immunized testimony against a defendant. Yeah, you can do it. And this whole Castigar thing is just what smoke and mirrors nonsense. Castigar is a Supreme Court case of the United States that basically talks about you can't use immunized testimony. If you give someone immunity, you can't use that against them. And it's a Fifth Amendment get around normally Fifth Amendment, your rights to remain silent, and nothing you say can and will be used against you. But guess what? They have a statute in Florida that says you are forced to cooperate if you're subpoenaed to testify truthfully. And guess what? That does not give you a license to lie. So when, I'm not going to say if, but when Wendi gets prosecuted, she can try to claim, hey, you used me as a immunized witness against other co-defendants, and now you're using what I say against me in my own trial, and you're using that to build a case against me. No, you know what? Nothing she said in her any of her testimonies was an admission of guilt. It was all self-serving in her mind, but what it actually was replete with lie after lie after lie, to an extent that you could charge her with perjury and then bring in some of those statements. But let's take it this way: if you exclude all the testimony that Wendi has given in court, keep in mind the interview she gave to Detective Isom, that was not something that she was getting any immunity for. So her entire interview can and should be brought into her trial. So really, you don't need to use any of her immunized testimony at trial if you didn't want to. But if the prosecutors were smart, they'd bring it forward with charging her perjury every time. So I think that this, like I say, this whole Castigar thing is that they're not using anything she testified in court, so there is no Castigar issue. So I've used immunized testimony before when I was a chief prosecutor and special assistant U.S. attorney, and it was never, I was never challenged of using evidence that was immunized previously and not handling it properly. So, but if they want to raise it, fine. They can have sufficient firewalls of the information. And like I say, nothing she said in her testimony was she trying to incriminate herself by saying, yes, I did this. She was trying to distance herself and backpedal. No, I didn't have anything to do with it. No, I never drove down to Trescott. So she's doing all this backpedaling and constantly changing her stories. So that's not an admission per se. Is it circumstantial evidence to show that, yeah, she's involved in this? Absolutely. But you don't need to use that. And so I wish we had. I need to ask John to do a short on Jansen's flip flop just in the last month, saying where she's going to be prosecuted to now she's not going to be prosecuted. So anyway, it's just such a joke. So he's obviously wanting to get business, or else he's best buds with Rashbaum and also Laurel. Laurel and him hang out as well when he comes to town. So I mean, what's that tell you? Anyway, enough of that nonsense. Yeah. So if you show you got 40 years experience and you continually flip-flop on this case and predict things that don't happen. I mean, if he makes a prediction, if you're a betting man, the best thing to do is bet against his predictions, because most of them turn out to be wrong. So what's that get you? Anyway, I'll move on from that, but oh, that's another thing. Yeah, thanks, Spire. Yeah, I had heard that he was claiming, I didn't see this, but I've heard this from enough sources. Jansen was claiming that Donna would be acquitted on count one, and they would take till all of Friday to come up with a verdict. And count one, she'd be acquitted of count one. Yeah, that's what I'm hearing, folks. So guess what? Right there, that tells you what 40 years of trial work gets you. Is he actually doing trials? I mean, the only thing we hear about is this big guilty plea that was offered to him by the state. So, I mean, anybody can be offered a guilty plea. There's no skill required for that. So anyway. Yeah, also the plea deal. Yeah, plea deal. She was when it wasn't and all that. Yeah, it's just. So anyway. And you know what? if he's always referencing me indirectly, but let's look at what other people are saying. You know what? The naysayers that we've seen before, other attorneys, folks that knew Dan and Wendi, they never came out and said anything about Wendy's guilt. They only started after. I've only seen it after I started this channel that my brother's pushing and prodding. So with that, I want to go ahead and show you this interview here. This is Dan Markel's attorney, the Honorable Stephen Webster. This is a guy you can tell this is rock solid character-wise. He's not flip-flopping, and he says he became a better father because he met his client Dan Markel and was so impressed by his love for his kids. So let's see what he says about Wendi Adelson.
In this trial, from watching it, that there was almost like a foghorn being put out, and that foghorn was all about Wendi. And so there's been so many questions about whether or not Wendi Adelson could possibly be charged in this conspiracy, in the plan to murder Dan Markel. What are your thoughts on that? What are you seeing coming down the pike? Because Jack Campbell, right now is saying things like, any decisions we make will be made in time, and they're giving the answers they're supposed to be giving.
I believe that she will be indicted, and I agree with you. I didn't watch the trial. I was under subpoena, so I didn't have the ability to watch the trial as it was unfolding. But I've had a chance to go back and see some snippets, and there's no doubt in my mind that the state highlighted a lot of pieces of evidence that really were damning for Wendi. And I agree with you. I feel like that was by design. And I think there certainly is enough evidence to not only indict Wendi, but to convict her in less than 4 hours, just like these last two juries did.
What specific evidence do you think is the strongest against Wendi Adelson, since you had a front row seat to all of this? I mean, you were there for the divorce, for everything.
The strongest evidence for me is the drive-by. There's people in Tallahassee will not conclude that was just by happenstance. And even if it was by happenstance, what mother pulls up to the street where her children live with her ex-husband and sees crime scene tape, like blocking that road, and the police all around the house of her children and her ex-husband, and just makes it a 3-point turn and goes on to the liquor store and doesn't bother to call anybody just to make sure. And, in her testimony about, I thought a tree had maybe come down. There'd been thunderstorms the day before. Trees come down in Tallahassee all the time. Okay. I mean, we have big canopy oaks, and they don't come out with crime scene tape and rope off the streets. And our Florida Highway Patrolmen and our police officers, they actually have chainsaws in their tailgate or their trunks of their cars, many of them. And they literally will get out and just cut the tree if it needs to be and roll it out of the way, out of the road. So, that there's no reasonable explanation for her driving up to the crime scene, seeing all that, and then driving away and not making any attempt to verify that her children were safe or even that Dan was safe. I mean, I know she hated Dan, but still, I mean, if something happened to Dan, wouldn't she want to go get with her children and make sure they were okay and shield them from how they learned that something bad happened to Dan? So none of that, to me, is always going to be the strongest. And that is, to me, it's a direct piece of evidence, because she needed confirmation that Dan was killed and she couldn't wait.
Tell me about the significance of the day that Dan was murdered in the custody case, because the divorce was final, but there was more going on behind the scenes that you were preparing to do and preparing to file.
Wendi had filed a motion to enforce the marital settlement agreement and a motion for contempt because Dan had not paid some of the monies that he was required to pay under the marital settlement agreement. Dan was upset because he was convinced that Donna and Wendi were engaging in a pattern of behavior that was intentionally designed to alienate him from his sons. She wasn't honoring his time with the children the way the marital settlement agreement required it. She wouldn't take the children to school a lot of times, which is a real problem for him, because he would go and sit with them at lunch. And plus, and even the director of the school was saying, these boys need to be in school more than they are. She was enrolling them in things without consulting Dan. And then the biggest thing for Dan was that he knew Donna was saying ugly things about him around the children, calling him stupid, saying she hates him. And so he knew that that was what she wanted to do. Donna wanted to do everything she could to drive a wedge between him and his sons, and he wasn't going to have it. And that was the tipping point for Danny. At that point, he decided, I'm not paying you any more money. And he knew she was going to file a motion for contempt. And he filed a cross motion for contempt. And he pointed out primarily that Wendi had fraudulently concealed significant assets that she had possession, dominion, and control over when she submitted her financial affidavit. So in a divorce, you submit a financial affidavit where you attest to what your assets are and your liabilities. The other party does the same thing. It's critical because the court has to have a full picture of the assets in the estates in order to equitably divide those assets. So it's a critical part of a divorce. And if you intentionally conceal those assets, you're preventing the court from having a full picture of what's what, so the court can figure out what's an equal divide. And it's just straight up fraud. And so Dan had really solid proof that Wendi had done that. I mean, unequivocal proof. I think she would come in now and say, oh, it's no big deal or whatever. But he was alleging a total, it was about $200,000 worth of assets that she had not identified. So that was when Dan hired me. They had already filed his motion for contempt, had already been filed. And he hired me to try to help navigate that and litigate those two motions for contempt. And so what I had told Dan was, I think the best thing we can do is file what's called requests for admissions. It's a civil discovery tool that you send over to the other party, asking them to admit certain things or deny certain things. And primarily, I wanted her to admit that she had concealed those assets, that she had not listed them on her financial affidavit as she was required by law to do. And like I told Dan, it doesn't matter to me if she admits or denies it, because we're going to prove it one way or the other. So if she denies it, it's going to be a second act of fraud on the court that she'll be committing and perpetrating. Given that she was a lawyer, and I guess presumably still is, and a law professor, I told Dan, I said, look, I don't like the idea of doing this. I don't like the idea of proving these things, because I really believe it will have dire consequences for her professional licensure. I don't think the Florida bar would have taken it lightly if we proved that she committed fraud on the court. You can get, the bar can be forgiving on many things, but they're not forgiving when you're dishonest as a lawyer. They're not forgiving when you commit perjury or when you steal money from your client's trust account.
So this is really serious. This is the thing that I thought was the main crux of why the urgency of the murder was required to make this go away, that Dan was becoming such a threat to her. And this attorney is somebody that's very formidable in court. He's a no-nonsense kind of guy. If he comes into court saying he's got the receipts to be able to prove stuff up and you're going down, I think this guy, you can take it to the bank. And this is serious stuff she was facing. And so therefore, it wasn't just the convenience of having the sunshines closer to Miami and Wendi being able to live it up down in Miami versus that country hellhole hick place known as Tallahassee.
That's the kind of stuff that gets you disbarred. So I told him, I said, I have, real kind of.
Right there, he's saying this is the kind of stuff to get you disbarred. So this is one of the indicators from way back when we first covered that. And I thought, you know what? There's nothing more terrifying for a lawyer than somebody trying to go after your bar license, and nothing to incite anger than someone trying to go after your bar license. And, it's one thing if there's something that's frivolously done to go after your license, but when you have no good defense for what is being brought up as an accusation against you, then yeah, that's going to be very, very terrifying for somebody in Wendy's shoes.
Reservations about doing it. If we have to do it, the truth is the truth. So if we have to go to court, I'm going to go in with the truth. But I said, I feel like I owe it to you, your children primarily, to at least try to speak to her attorney to see if we can't find some resolution for these disagreements short of, full on hardcore litigation that might ultimately cause her to lose her license. So it's the only time in my career I ever did it. People have criticized me, and maybe justly so. But I went over and had a meeting.
Well, it's just not the license, it's the loss of her job as well, because Dan could have just said, look, I'm not working here if you keep my wife on staff as a part-time professor, adjunct professor.
With her attorney on June 24th. And, I just kind of told him, I said, look, I feel like this litigation is going to be consequential. And I really believe for your client, more so than mine, I'm not in here just boasting or saber rattling. I legitimately think that if I'm forced to defend these allegations and advance Dan's allegations, that it could cost your client her law license.
Wow.
So my client's got the proof that she engaged in some really bad faith conduct, and he was just kind of dismissive. And so I was leaving.
But you know what? He would have passed that on. He had a duty to pass it on to Wendi.
And I said, thank you. Appreciate your time. And I was on the way out the door, and he called my name. He said, Stephen. And it was the first time I felt like he was being serious. And he said, I know what you're trying to do, and I appreciate it. And I said, well, I feel like we owe it to our clients and the children, to at least try. I said, but if I haven't heard, from you, I'm going to file something on July 18th that I genuinely believe is going to be monumental. And once I do it, there's going to be no going back. And so that was it. I told him that was the day I was going to file it. And Danny and I were working on it the day before the request for admissions. And we were supposed to finalize them that morning. I spoke to him that morning on the phone, but I couldn't. At that moment, I was had a bunch of distractions going on. And so I just told him, I'll call you back once things have settled down in a couple of hours. And that was when I called him. It was about probably 30 minutes after he had been shot is when I called him to finalize those requests for admissions.
Have Jack and Georgia been in touch with you at all, or at least Georgia, about testifying in front of a grand jury or anything to that effect?
Not in a grand jury. They've had me under subpoena the last couple of trials. I testified in Charlie's. It was more so about pushing back against the idea that it wasn't a contentious divorce. And I think they kind of wanted to humanize Dan a little bit more. Dan had a real profound impact on me personally because of the way he loved his children and the way he acted as a father. He really did inspire me to want to be a better, more attentive father. I'd never seen a dad like him. So I think they wanted a little bit more me to add some of that flavor if I could.
So if you were a betting man, Stephen, I mean, what would your crystal ball, where would you put, where would you put your chips on this? Do you think we've got something coming soon, or do you think it's going to be a couple of months? I mean, there's really no statute of limitations on this. So do you think, where would you place your bets?
I think I was on your show once before, and it was around Christmas.
Yeah.
I guess of
2023.
23. Yeah, man. Wow. And I told you then that I believe they will ultimately indict Wendi, and she will be convicted, in my opinion. And I still feel that way, even more so now. Like you said, the foghorn. I mean, I don't think it was just coincidental that there was so much attention paid to the evidence that points to Wendy's involvement and foreknowledge of the murder. And I think I would expect, I kind of think we're looking around 3 months is what I think. I think that's probably a reasonable time for a grand jury to be impaneled and for them to bring it.
Why 3 months? What is that? Why that time frame?
My gut just tells me that. I think, it gives the state an opportunity to kind of take a breath, go back, work on all the cases that they weren't working on for the past 2 months, to make sure they're kind of up to speed on those. And then get regroup and get their game plan on how they want to approach the next grand jury. And so I just think that's a reasonable kind of time frame. I think also, that would probably put trial somewhere in early fall of next year, which I think is a good time for the state. We'll have the students would be back at FSU and at FAMU. So I think that's kind of a good time for a jury pool. My understanding is that this jury was skewed very young, and it worked. So, and Tallahassee gets a lot smaller when school's out. So,
well, and just thinking about, you're talking about 3 months. I mean, that puts us then past Donna's sentencing as well, the formal sentencing. So,
yeah.
Well, Stephen.
All right. So there you go. This guy is a local there. He was Dan's attorney. And he goes to that courthouse. He works with the state attorney's office on a daily basis. He's a criminal law practitioner. He's willing to do family law just to help out Dan because he realized he had a solid case. So things are going to blow up in Wendy's face. She had a deadline to respond, and if she did not respond by the 18th, he was going to start taking further action. And that 18th deadline was the day that Dan Markel gets murdered. So you're telling me that's not a coincidence? That has not been brought out in court before, when he's talked about how there was a deadline on the 18th, and that happened to be the deadline that Dan was murdered. So it's unbelievable. If that's not a smoking gun on motive. Okay, you guys are saying something about, let me back up here. Something about Isom was on another channel and had Detective Isom interviewed. I've not seen that, but apparently Isom was all pro Wendi type or something to that effect, which is, see, you're saying the interview that Detective Isom recently gave won't have an effect on Wendi being arrested and prosecuted, will it? I haven't seen the interview, but I wouldn't really worry about what he says as to anything he says in defense of Wendi. If he says anything in defense of Wendi, let me just tell you this. It's another indicator of the kind of scams going on down there in Tallahassee, because you know what? I've said this many times on this channel. Detective Isom got snookered by Wendi. He had no idea what he was dealing with. He fell for it hook, line, and sinker. He cleared her within first 40 minutes or less of that interview. You don't bring in a victim witness that soon and go all that kind of effort. He did some rudimentary things. He didn't do a full scan of her phone when he should have. So he basically was doing some rudimentary things to treat her as a suspect, but you could tell he was checked out in his mind that she wasn't involved in this. But you know what we've heard before from Jansen is that, oh yeah, he suspected Wendi from day one. From that first interview, he suspected her. Well, you know what? Really, now that's not coming out. So who's telling some fib on this story now? So anyway, somebody's fibbing on this. So anyway, a lot of crazy stuff swirling around down there in Tallahassee on this case. So I'm not concerned about what Detective Isom has to say. And if he does think there's some things that look like there's not enough on Wendi or whatever like that, he's not a prosecutor. He's retired. And so it's not up to him. The 2 you're saying you found that Detective Isom's memory is failing after 11 years. He just wasn't as sharp as he normally would be, so. Leah Stevens, you do not think Detective Isom defended Wendi at all? He may have been speaking carefully, knowing that she's likely next. Yeah, and I've credited him with at least keeping her talking for 5 hours because she was thinking, hey, he's believing me. Once in a while, he, when you make a comment that she got scared by, she'd start doing the fake crying. Stacy Q saying Tim sim for Wendi from the beginning. But he's made some damning comments too in the past. He just hasn't said anything in the last 2 years or so. What somebody needs to ask Jansen is, are you telling me you think she's innocent? What's he going to say to that, right? Because once he says, yeah, if he answers that question, then you're going to really find out how much he's really trying to be a defense counsel for her or another Adelson. Because if he says, yeah, she's guilty, I just think they have maybe evidentiary proof problems, then he realizes they're not going to hire him if he makes a public statement admission that he believes she is guilty. So, but he's able to evade that so far. Nobody's ever pinned him down on that question. As a matter of fact, you're saying Isom said he kept Wendi talking as much to get as much evidence because he suspected the family. Okay, but not her. Yeah, that's what I think makes more sense. Laura, you're saying Isom said he definitely didn't tell Wendi anything on the ride to the station because he wanted to wait until there was cameras on teller. So that right there proves she was lying about, as we always said in this trial, where she said she found out on the ride to the police station that Danny was shot. Allison, they should charge her with all 3 plus multiple counts of perjury. Okay, Amber C, you're saying that ML, which stands for mentor lawyer, said that Isom refused to answer some questions because of potential future trials. Okay, that's good to know. Yeah, I haven't seen that. I don't know if I'll comment on it, even if I do look at it. KCL, you're saying you hope Wendy's defense get a hold of that interview. Well, he did not opine as to Wendy's guilt. I find that very surprising. MG, you're saying who takes a shortcut that has about 12 speed bumps. So yeah, Leslie and I were given a ride down Trescott when we were down there, and lo and behold, yeah, I've been down there before with John for Charlie's trial, but yeah, Leslie got to see it firsthand that this is not any shortcut. Speed bumps, narrow roads, windy roads. Larissa Harris, Isom interviewed the spouse or ex-spouse, always the first suspect, but he said he needed to get info from her. Eliza, you'll never forget her and her frigid heart buddy Jane or whatever her name is laughing and giggling at the police department while Dan is dying in the hospital alone. Yeah, that is pretty cold. Jay King, Dan gave Charlie 95. What score do you give Josh and Jackie? Wow, wow, boy, that's I think what I found about Zellman, and keep in mind I saw him in the hallways and stuff like that, I didn't see Jackie Fulford in the hallways at all. I don't know what she was doing, but never crossed paths with her. I did say hi to Zellman, and I don't remember if he said hi first or I said hi, and he asked, "Hey, how you doing?" I said, "Good, how are you?" And anyway, we didn't. That's the extent of it. But he was. I think he comes across as a likable guy, very conversant with the prosecution, as we've seen. I guess you wouldn't see it on the live streaming so much, but he's a guy that seems like it'd be easy to work with if you're on the other side. But I just was surprised that they were unprepared as much as they were. But keep in mind, they have really nothing to work with, and Donna would be a very difficult client to work with. So I don't really want to say too much other than the fact that they couldn't have done anything better to have a different outcome. Okay, he's saying it could have been different if Donna was prepared to testify. That's really an odd comment to make. I'm surprised an attorney would admit that. He's board certified as an attorney, so he's got extra training he's done, extra hoops he's had to go through. So, yeah, I mean, preparation wise, probably like a D. Yeah. John Smith, you know you're in trouble when your lawyer says, "Judge, you're laughing at us, make him stop." Yeah. So basically, he's trying to say that the public spectators were absolutely, ridiculing our client, and the judge let this go on. And yeah, it's. As a matter of fact, didn't defense state that in the beginning that Donna was going to testify? Well, I think I do recall that they brought up the constitutional right to remain silent. They had the jurors agree to that was something they couldn't hold against Donna. So that's the first time we learned that, hey, maybe they're not going to call her, but wow, to have Donna so ill prepared. No, I'm saying D for preparation. No, it's just that there was breaks. They weren't ready to go. They had to go back like after they got done cross-examining a witness. They'd have to go then confer with the other one. Hey, is there anything else that's brought out that I should ask or whatever? I mean, I don't know. I just thought it was very, very much something that even for witnesses that weren't that significant, they didn't bring anything out really of newfound revelation that they need to confer. I just thought it was. Yeah, I mean, the evidence is a complete for a grade for the evidence for Donna. I mean, it's like zero. There's zero to work with. So to get a D with zero evidence, that's still a pretty good score. So in terms of likability, I thought Zellman had a likability factor with the jury. So in that sense, he was, let's say he scored a 90 with that. I thought Fulford acted really strange. She kept on having her head down. You couldn't even see her face. Her hair was covering over her face. I thought that was very, very, very unusual to see. So I think her involvement in things that she did, I thought those were very, very much, in a way, more concerning, more disorganized. Archie, as bad as Rashbaum and Charlie's pathetic defense story was, he did seem definitely prepared. Yeah, I agree with that. But in the end, the judge didn't get mad at him. He's very patient. So Sandy B. Donna's best chance is ineffective counsel. Yeah, I think that ineffective counsel, I think they have nothing to work with. I think that the most significant thing, the thing of any significance, is you as an attorney admitting that your client was ill prepared, and you're basically saying you didn't prepare them properly. That's like an admission of guilt by the attorney. So I don't get that. But do I think it's enough to say that she's going to be granted a new trial for that? No, I don't think there's any reversible error there. Juju, yes, she was forced out off the bench. You're talking about Jackie Fulford. She had some issues. I won't get into them. GWH, can you tell us what charges Wendi would be charged with if she had foreknowledge, but maybe not direct involvement? Well, you don't have any direct involvement. What do you mean direct involvement? You have some involvement if you give things like a license plate number. If you find out the schedule, oh, hey, Dan, are you going to be available? Are you going to be in town the 14th to the 18th of July? And you're down there where your brother and family members are of Florida, South Florida, and you're wanting to find out when is a convenient time for the hitman to show up. That's not, that's not to you direct involvement. So there is direct involvement. So they're going to go with the same charges that we've had for Charlie and Donna. The Sarah 730, even when the defense was questioning their own witnesses, the examination was short, i.e., family law expert Ms. Bailey. Yeah, I think some of them, I don't know what more they could have brought, though, really. I thought it was pretty weak having Bailey and the other attorney testify that it wasn't really contentious trial, a dispute between Dan and Wendi. I mean, that's pretty bizarre. I can't believe an attorney would say that wasn't contentious. Larissa Harris, Georgia was brilliant with the tabs. Wendy drives me crazy, batting her icing. I don't think so. I don't think I did. She was definitely scared testifying, seriously scared testifying this trial. She knew there's a chance of her getting arrested this time. All right, so Martin's, you're saying was Sarah Dugan accepted as a judge. Interviews conclude this week. Well, for this case's sake, hopefully she's not selected. I think she will be down the road. I think her excellent job we've seen here across the world, she'd make an excellent judge. Mr. Dramatic, do you agree with Webster? That'll be 33-ish months until Wendi gets indicted. Well, what I said was it made most sense to arrest her while she's there in town. And if you're not going to do it right then, wait a week and go nab her before she has a chance to try to flee the country. But I said, knowing the slower pace of that office, it may be till the end of the year. So if they don't arrest her by end of the year, then there's some serious issues going on with Jack Campbell. But I think I just can't imagine him being that asleep at the switch. Heck, bring me down. I'll try the case for free for you. If you guys don't have the courage and backbone to do it. Yeah, Cass, you could clearly see Wendi was scared. Yep. We, the privileged few, Georgia collected lie after lie after lie from Wendi. I agree with that. Jay King, yeah, when Georgia said love, you love it when Georgia snaps back at tab. Yeah, like there's like so many volumes of things that she said that we can slice and dice you up on. Leap Day Boy, Donna's defense witnesses were very condescending. Yeah, they were. They were coming across very, very much as they were above. They're above these fifth grade intelligence level people on the jury. Leslie B, you're saying Linda Bailey made so many mad. Her Google reviews. Thanks, Lynn. Beachman, you're asking if I'll cover Karen Reed's civil trial money. Wow, I didn't. Is that going to be televised on different court channels? No, I will not be covering that. That's not my plan anyway. It's just sort of going to repeat a lot of the same stuff, and it's not a criminal trial. Certain civil trials, I guess I'm open to covering, but short of that, I prefer to stick with criminal cases. Denise Risha, yeah, how can that be contentious if it ends in murder? That's one of the things that I asked the prosecutor. Oh, it wasn't contentious. Well, how many of your clients or your opposing party clients have been murdered before the court litigation was finalized, right? So I think she said there was like a suicide or two. Bailey talked about that, but an actual murder where the court hearing cannot be pursued any further because one of the parties is murdered. So yeah, or whatever help they could use down there. You just need some encouragement to go forward. They will get a conviction. If they pursue it, they'll get a conviction on Wendi. There's no doubt in my mind. I've said that from day one. Okay, you're saying it's going to be televised, starts Monday. Yeah, I got a really busy schedule Monday with Leslie, so we'll not be available to watch really most any of that. I don't know when the Brightigan case is going to kick off, but yeah, I would like to cover that one as well as Brian Walsh. Also, the Aaron Spencer one in Arkansas. I don't know if that's covered. So okay, well, I'm going to go ahead and sign off, folks. Thanks for supporting Justice for the Markels, and hopefully I jump on real soon again to talk about the arrest of Wendi Adelson, and we will have more coverage. Don't know which case I'm going to cover next, but so I'm not sure exactly when I'll be back on, but stay tuned, and we'll cover something that cries out for justice, and we'll go from there. So y'all have a great weekend. Be safe. Yeah, I've heard of the Ellen Greenberg case. That's in Philadelphia. She was murdered and they call it a suicide. That's really an outlandish, crazy situation there as well. A lot of politics, I think, involved there. So anyway, talk to you soon. Take care. Have a good night.